when she was retained on the case, it was already the first one.
Ah.
And there was another lawyer on it who apparently hadn't done a whole lot to prepare, and the DA's office was perfectly happy to take that case to trial first. Once she was on the case, they tried to sort of slow roll her case, and maybe with hopes of getting somebody else up first. But I think there are a lot of lawyers on that case who are just sort of on the case, waiting and seeing what happens without doing a whole lot of preparation.
Sure.
And I think she had 7 months to prepare, 6 months to prepare for this, what's been 20 days of testimony.
Mm-hmm.
Wow.
And in the midst of that, the DA's office turns over witness interviews, documents that had not previously been produced to the defense.
So Abel Reyna has been telling the court all along, we've given the defense everything. We've given the defense everything. We've given the defense everything. And then more stuff starts to come out. Okay, well, we didn't know that the Waco PD had that. Okay, well, it's your job to know, and you told the court that you gave us everything, so would you please give us everything? And the judge says, give her everything. And finally, into trial, maybe a week into trial, maybe a week and a half into trial, the judge signs an order to each of the involved agencies ordering them to produce everything to the defense. And at that point, the DA's office says, oh yeah, we've got this statement that was recorded in the DA's office that we haven't turned over. So the elected DA is lying to the court, right? Yeah. Because either he doesn't know what was turned over and he's acting as though he does, which would be a lie, or he knows that it wasn't turned over and he's telling the court that was, which I think is probably what happened. And
but wasn't he in the room when the statement was made?
He left the room,
right.
Because that's right. He was in the room when the statement began, but he left the room because he knew that the witness was lying. That's not justification for not turning something over. No. And this is the same mistake that the state made in the David Temple case, right. Where he got habeas relief years after being convicted because Kelly Siegler had made this call, oh, we don't have to give that to the defense because we don't believe it to be true. Prosecutors are going to have to learn that whether you believe it to be true or not, it's exculpatory and you have to give it to the defense. Was it true? Was it not true? It doesn't matter. It's still Brady.
Yeah, I mean,
Now, the other thing about that in this case is that it would have affected the way that the defense tried the case from the beginning.
Right.
So not only, you know,
and all she got was like a day off to review it.
45 minutes, I think.
I thought they had
recessed. I think she got some, you know, oh, you can look at it overnight. We're going to get out early today.
She moved to have it dismissed for prosecutorial misconduct. That ended up getting denied, and then she asked for a continuance, and the judge gave her 45 minutes to look at everything.
Yeah.
Which I think that's horrible.
It's absurd. You know, if I was a judge, you know, if I was a judge, I would know that the entire planet of everyone interested in this case is watching, and knowing that I could get flipped, I would probably I'd do everything I could to.
But you'd try to give everybody a fair trial, and you know, the fact is that not a lot of people are watching this case. People have forgotten about it, and the chief prosecutor, Abel Reyna, the guy with the $20,000 wristwatch, your former law partner.
Yeah.
If you're the judge, right? So it's Waco, it's incestuous, it's the lawyers there. From what I've seen of the lawyers in the prosecutor's office, they're not great lawyers. And when you have a DA's office that's not strong, what do you get from the defense bar? You get a defense bar that's not strong. What do you get on the bench? You get a bench that's not strong. I have an appeal up there where the first line of the appellate prosecutor's brief is, defendant did not ask for oral argument in this case. You know what the first line of my brief to which he was responding was? Defendant requests oral argument. He files this brief with the Court of Appeals where the first line of it is blatantly untrue. It's just, I don't know, I think that people don't hold their feet to the fire, and so they don't get good. And when you have an incestuous little community where the judges give the prosecutors whatever they want, prosecutors don't have to be competent.